as well. So
And one issue is involved by how we deal with.
exactly. Exactly.
Right.
Oh, excuse me, sir.
Uh,
Actually, Your Honor, I'm using it as the timer, so I know how much time I have. It just helps me pace the argument, Your Honor. No. May it please the court, I represent Advanced Basement Products, the appellant. I would like to reserve 5 minutes for rebuttal, Your Honor.
I'll be brief.
I'll be brief, as the facts in this cases are unusual, but not particularly complicated. There are two foreclosure cases. In the first one, my client, the appellant, purchased a house. I'll be discussing Liz Pendens today on several occasions. No Liz Pendens was filed at all in the first case. The key issues in this case are due to timing. We believe this is the case of first invasion in Florida, as none of the relevant cases have the exact timing issues that we have here. So to begin with, I'd like to go through timing issues in more detail. On January 13th, I'm not entirely, I don't know I would entirely agree with that, Your Honor. Right now, the system, the certificate of sale was filed on January 14th.
Then the 10 days expired.
And the 10 days expired. At that point, the clerk of Manatee County could have issued at any point the certificate of title. The statute very clearly, whoever appears to be the owner of it, because right now we sort of have three different, clearly in the beginning of the 10 days after the certificate of sales filed, and my client has very limited ownership rights. And if the Liz Pendens were
sale operated your client here is the owner of record within the statutory definition.
No.
So you would have had to
no, Your Honor, not at all.
you would have had for that to be here.
I would make a slightly more subtle argument, Your Honor, which is there are three time periods here. One, you have the 10 days with the certificate of service. After the certificate of service, there's a statutory 10-day period. That period ended. According to the statute, the clerk then has a duty to file the certificate of title. They didn't do it in the interregnum, after which the clerk could have filed the certificate of title, but did not. The Liz Pendens was
right, and that's the operative moment, right? The moment that's whoever appears to be the owner of record. And if the appearance of the records, which I think is the appearance of language about it, which nobody has to go behind all that. If whoever appears to be the owner of record is presumptively entitled to proceeds, and the only way out of that is to satisfy section 4503, which your client didn't do.
Well, and going to your point, I don't think they're able to do that. But I would even go back. What does that exactly appears mean?
I'm not sure that's what the legislature intended. Does seem to be what you're.
Appears is very ambiguous.
I think you have to understand the context of Liz and title. Title land is always understood kind of a manifestation of an instrument, i.e. or which it appears, as title, right? I mean, that's me. That is just another way of saying what the or organization shows. I have wrong, yeah.
Right, no. again, appears, I would argue is ambiguous. I mean, the statute could have said whoever is the record owner. But again,
How
appears,
would that change the situation? Because the owner was recorded, was not your client. You know, until you get the files, you have
mhm.
ownership. You're advocating. Uncertainty in real estate transaction. Uncertainty in real estate transaction.
This would be.
I don't know that it's uncertainty. This would be only come up in extremely rare circumstances. We have a period of a couple of days in this case.
And how are you supposed to issue, how are you supposed to get title insurance on any of these kinds of transactions? Awesome.
They could go and look at the past record. I don't know that it'd be any different than doing title and insurance in the other case.
Except in other case, they won't do that. And there's a party, even in my look at the allegation of the prior. But you're advocating, no. You need to go like what litigation. How do you look at this?
It would only come up in situations where with a very time period with this fast path. So
It would only come up in situations. So would this be a lot of extra work in a very rare amount of cases for the title insurance companies? I agree, but then it goes back to the point, it would be in a very rare and small amount of cases. We put absolutely, and we put extra fees on different companies or different individuals to do extra things in certain cases all the time. I would go back to the statute, which is 35.02 section 1 subsection A. In determining an owner of record, a person need not perform a title search and examination, going to your point, but then it says it may rely on the plaintiff's allegation of ownership in the complaint.
It says may, that's on the order. It
It may.
doesn't say must, it really says may.
It's not, or
They may.
it says
Does this rely? pertain
can look at it.
from
Doesn't say must. It merely
defendants? Are you trying to make this apply this to your client's filings, which weren't in the nature of it?
That's an interesting issue because we have two.
that's an enclosure proceedings in this situation. The first one. And then the lis pendens, which isn't the issue here, comes in an entirely separate foreclosure proceeding, which again goes to the point of.
As far as the answer to this question, are you wanting, are you asking us to read subsection 1A to give your client the benefit of allegations in its moving papers? Or do you acknowledge, you agree that the reference to the complaint is filed by opposing mortgagee? And if that's the case, if the second option is the case, I don't remember what the complaint said if I looked at it in this record, but I'm assuming whatever the other mortgage said, which is the owner of record, you know, what is Quest.
And that goes back.
And again, that goes back to who's the owner of
Answer my
record.
question, not what you want us to do. What is your version? What's your view of how we're supposed to interpret that sentence? You brought it to our attention and wants to apply it.
But the complaint.
The complaint would be in the second foreclosure case.
Complaint that was filed by the foreclosing mortgagee. And they alleged
Exactly.
that Quest. Okay,
Yes.
so the trial court was entitled to read that. Then the trial court could rely on them.
I wouldn't say why entirely, but I mean,
The
it's,
legislature said they could, and you just agreed that it's in the complaint.
I don't think that the legislature said they could rely entirely though.
I don't know why we're doing it and
Mhm.
Fact of the matter is,
And we had considered the issue that the clerk may be under a party at fault, but there's also a circular issue here in that when I'm here, you bring up the issue what the clerk did or didn't do. But had we not appealed the disbursements order and gone against the clerk to begin with, they would have said, why didn't you appeal the disbursements order? So I'm aware of the issue you're bringing up. We had to choose one to begin with. So I take those, sir. This case turns on an extremely specific and narrow issue of timing, 2 days in January 2022. There are no Florida cases that deal with disputes in this very time frame. After the time the clerk should have, what rights does the purchaser actually have in that particular situation? My counterpart in his answer brief goes through several cases that are indeed about surplus disbursement, but none of the cases that he discusses actually has this specific fact pattern. I'm sure the court has read both his answer and then my reply brief, which goes into this. So I won't go into detail unless you have questions. But none of the current case law deals with this tiny thread of time that we're dealing with.
Reaffirms that we found to follow the legislation. In the statute, and say pronounced in the statute, is the event, who is the owner, who appeared to be the owner of the record, which is been through now. On the date was filed. I read the cases. I understand you don't have this case already in a recorded opinion, but none of the cases that your opponent relies on daylight in each of those situations, each of those things happen. Whoever was the owner of record was entitled to a certain progress.
And then I would just refer your honor.
Right. And I would just refer your honor back to the conversation we've already had about the meaning of a peers. So
how do you get around saying other than your arrow time frame because we outside the purview of everything else. Outside the purview of everything else. Yeah, for a second on that. Okay, legal rules state of academic.
I would say
I would say that the legal rule is determined by the timing. So I would use the timing to get past it.
I mean, that is not a feature, and that is not a feature. It's just, it's strictly, the only temporality that matters brings in accordance with Machiavelli, and it's a specific title issue. That's the only temporal point of view.
But there was no need for them to discuss any.
But there was no need for them to discuss any other issues. In that case, the certificate of sale was issued on, I believe, January 17th of some year. And then the Liz Pendens was filed on January 23rd. So that was 6 days later.
This is so even whereas here there has to be business purchase transactions prior to actual requirements did not be until after the recording and until after the recording. That doesn't matter. That's a one-off because of 2 day gap that occurred.
I think it
Can be distinguished.
I'm not sure.
Yes.
I'm not sure. You're asking us to receive. I think you're asking us to receive Machiavelli. Receive from it to create a special one-off exception.
I don't think it would be a one-off exception, Your Honor, because when I've spoken to other lawyers, this is, even though this is I don't think this particular issue has come up appeal. It's come up with other lawyers before, and it's been an issue. None of them actually bothered to appeal. Right.
So
I don't think that it would be a one-off. I mean, I agree this is not going to come up very often, but I've spoken with. I can think of, I have been told of 2 other cases where this exact fact pattern has happened. No, I mean, that's, unfortunately, there's a certain amount of truth in that, Your Honor. Now I just want to go on to briefly address the motion to intervene issue. As the court is aware, there's some overlap between the two bills being filed here, which is why they're being heard together. I'm about running out of time. I'll just make my brief point. If the court decides the appellant was the record owner of the property, then the motion to intervene should be granted under all of the case law. If the court decides the appellant was not the record owner at the time, then under all of the case law, the motion to intervene should be denied. I think that's very clear. I think that's what Carlisle says explicitly. I would even attempt to speak for my counterpart here that on page 29 of his brief, he would agree with that statement too. So if you agree on the issue of the record owner, the motion needs to be granted, and if not, it should be denied. And then again, I reserve 5 minutes for my rebuttal, sir. Thank you, sir.
Please, the court counsel, Christopher Hicks, Quest. I was trial counsel for this matter as well. I think Judge Lucas, you hit it on the head. What's being asked is to recede away from McAnally of this court, Judge Silverman, Morris, and Judge Kelly, and a thorough analysis. And the effects of that make a current exception would be, I don't want to say drastic, but it would be beyond the bright line rule that Your Honor, Judge LaRose, had indicated. And it would be dangerous because exactly what happened in the Iaconelli case was one as quoted by this court. That's when the process starts, but it's when certificate of title hits. And what does then creates that ambiguity and uncertainty for any of the future foreclosure cases, which is why in the Iaconelli case, Jupiter House went and technically won the case, but the court said, no, you weren't even allowed in, right? And so then you would have so many uncertainties in all of these other four cases, which is exactly your point, Judge LaRose. Yes.
In the first one, but it was independent, right? And it was the current record.
Yes.
And so it knew what the things were with respect to the time and issues of their city. And Quest got the $55,000 surplus in the first foreclosure sale. So there's two issues that I'm getting into. One is that the AVP had this right, was to receive the title in any manner during the time period of violence. So sort of racer. And how is it that Quest, how is it equitable that Quest ends up with $55,000 surplus in the first case, and I don't remember that number the surplus is right here, but it's a lot of time. And Quest out effectively the non-payment defendant in the first foreclosure makes up, essentially that doesn't strike me as equitable in the context of an equitable proceeding. And
I understand.
That's the thing. If Quest showed up one day and we had these facts, I wouldn't have these questions for you, but I do, and I appreciate you.
And I understand Your Honor's position, and unfortunately, that's the way the law is written, right? And that's why I had also said during my oral argument that was not rebutted by the appellee in the lower court matter, the Suarez case, which is a similar fact pattern in which, and we cited in the brief, which there were two mortgage foreclosure actions going forward. Both was the owner, and the owner at the time of the first and the second, despite the first one being obtained by another title holder, succeeded in the second. Yes, Your Honor, I was cited in those as well. Yes, Judge.
No, I'm not sure. I said this was my question, but I appreciate it.
No, I'm trying to detail my explanation, right? But that's the way that the law is written, right? And that's because, and then I'll get to my next point onto that is, that's the way that the statutes are written, that's the way the legislature wrote it with the intent. And then what you do is you go to actually Judge Sniffin's decision in the argument on the inequitabilities of the case and why the motion to intervene was denied. And if I could have 1 second. I had just written down record. But he said that it would be inequitable to allow the surplus and the invention of the appellee in this matter, because then they would have the position of their title is superior to the title in this new foreclosure action where the second surplus is being argued and the benefits of the surplus at the same time. So the court has already balanced those inequitabilities that Your Honor is concerned about. And that's why the Akinelli case is ruled as it is, the Suarez case is ruled as it is, and already in addition to the right of redemption, which was the sole reason that this appellant has to even get into the case was just to pay off the loan anyways. It was only an afterthought, but they did no action to force a certificate of title in the first foreclosure case to renew a motion to intervene prior to the hearing motion for surplus or any action that they could have taken until the day of. So respectfully, Your Honor, that's why equitably in this situation, it may seem as a windfall, but isn't under the law and under arguments of the trial court.
Forgive me if I'm asking you to repeat yourself.
Sure.
It sticks in my mind that Quest was a party to the first foreclosure was fair, and this isn't the first time Quest has been in some of these cases.
Understood. Yeah.
But Quest is sophisticated and it knows about the 10 days. And I'm not 8 days, they had a weekend or somewhere. It was just I'm curious why your client, your appellant, or opponent in this case, might have benefited from evidentiary to around the issue of who appears on a record in this case. And Quest is about to be
I understand that, Judge. Again, it goes back to the Suarez decision. There were two separate foreclosures on the same property, right? In this case, there was an equitable lien that was foreclosed upon them, and then an HOA lien, which is a hard written you didn't pay. And so there has been arguments and there has been issues of why should Quest, who was being foreclosed upon, knew that they didn't pay, then go and defend the lawsuit that they knew was improper. So they consented, and now we have that judgment, and that's how the issue occurs. So respectfully, Judge, that explains, I believe that should explain that position, and for record, where the excuse me, the court was detailing with equities of ABP coming into the case and having defendable title in the surplus is record 225. That's where the trial court argues that equitability or so respectfully, Judge, that's where we get to part. And then Your Honor brings the issue of the evidentiary hearing. There has to be some measure of finality, right? So when motions plus filed and set for hearing, right? There was no a request for a continuance for the evidentiary hearing until after the court already was saying, I'm sorry, Mr. Comer, your position under the record that we've already went over and I've made all of my details are as they are. And then he said, fine, tell me something. Tell me what we're going to hear here, right? And Mr. Comer just says, and we quoted it, I have to go find it, Judge. That's what the whole purpose of a proffer is. He didn't say, well, I need to do discovery. He actually didn't do discovery. He only made that argument there at the spur of the moment. It wasn't even presented in his other items. So he could ask for a continuance. He could have said, no, I don't want to have this. He could have said at the outset, I need to go to the clerk. Because as I think we all agree, it really is because we have an argument is for 10 days. But it's the clerk here and what their duty was. There wasn't a writ of mandamus requested. There wasn't a request to the first trial court to force the clerk to set the certificate of title, Judge. So respectfully, while I say all this is very narrowly tailored and there are some equitable discussion as Your Honor has brought up, I think based upon the law, the judge's analysis, which by the way is an abuse of discretion, and they're based upon the bright line rule and there not being, Mr. Comer has indicated any direct case on this issue at all already, shows that at least one judge or other ones, as Mr. Comer has said, that just hasn't been appealed, have ruled the same way. So respectfully, Judge, we would say that the equities in the law are clear on that, and we would rely on the rest of our briefs unless there's any other questions.
Thank you.
Thank you, and we would ask that you affirm the lower.
Yes, I'll just speak. Please. Judge LaBrie brought up the issue of the equitable issue, and I think that goes to the the issue of the inchoate rights, which has been discussed, that the purchaser has inchoate rights in the period between when the certificate of sale is issued and when the certificate of title is issued.
And I don't think that
If we're going to distinguish Occinelli at all, it would be to set up essentially different levels of inchoate rights. In the sense of the first 10-day
there's one level
statutory period, there's one level of inchoate rights that the purchaser has, which admittedly is not very much. We all know that based on the case law. But that once the clerk has the duty to file the certificate of title, there's a different level of inchoate rights, which gives, if not full ownership, level of ownership, which it's the same principle, but I know that phrasing isn't necessarily very popular in all circles.
What the legislature said. So.
And again, I think it's an extremely bright line. It's only a almost extremely bright line that does allow for a certain amount of compromise in unusual cases. Penumbras, yes.
I'm intrigued with the possibility of having levels. Like, it's not going to help title companies. Right?
It would come up, on a frequent basis, so the title companies would know that it would be another thing on their checklist that they would have to look at.
I'm not even sure.
Something. Anyway, that's my comments on that. Pat, do you have any further questions for me? Thank you. I appreciate you giving me the opportunity to appear before you, and again, I hope you overturn the decisions. Thank you, sir.
Drive safely.